My purpose today is not to sell you on anything or to convince you of a particular point of view. My purpose today is to assist you in understanding your obligations under the superintendent's new rules and hopefully to point out some areas that as managing brokers you need to put your mind to. So let's just go to a bit of an overview that I've just discussed. So a bit of a background, what's changed, changes ahead, how to prepare for change, and then time for questions. So let's go to a bit of history. In 2005, those of you that have been licensed for some time will remember that through provincial legislation, the real estate industry was afforded self-regulation. And then in the summer of 2016, we lost that. That gave rise to the appointment of a new superintendent of real estate, and that office co-regulates with the council. So OSRE, Office of the Superintendent of Real Estate, creates the rules. The council interprets and enforces the rules. I think this is an appropriate time to mention, as you would have all seen in the news last week, that Minister James announced a review of the regulatory framework, and that report is going to be due to the minister on June the 15th. So June 15 is going to be a busy day, the report to the minister, and also when the new rules come into force. Let's briefly review what has changed already. The new rules were announced in 2017. Those are the ones that you see on the screen here. The superintendent in March announced a couple of other new rules that were under consultation until last Friday. So we're expecting news from the superintendent's office in the next short while with respect to where they've landed on those other rules. These rules are disclosure of representation in trading services, disclosure of risk to unrepresented party, disclosure to seller of expected remuneration when offers are being presented, restriction on dual agency in trading services, and dual agency in underserved and remote areas. I'm first going to deal with the disclosure of representation and disclosure of risk to unrepresented parties. The forms for those are finalized, and we will hope to have them out in the next couple of weeks. We would think by mid-May, those forms will be available, so licensees can familiarize themselves and their clients with them before they come into force in mid-June. I'll also mention, and some of you will know this, that the council communications staff have been working and developed apps for tablets or phones that licensees will be able to use for the disclosure of representation in trading services and disclosure of risk to unrepresented parties. That way, they would be able to communicate electronically with their brokerage, send the forms in, and also provide them to the consumer. So both of these disclosure forms in all instances will need to be delivered to the brokerage, as will the disclosure to sellers of expected remuneration when offers are being presented, and the dual agency in underserved remote locations. Now, the dual agency prohibition, I believe, is the one that has caught the most attention of the industry because it is a substantial shift from common business practices. But we'll touch further on this as we move through the presentation. Now, who do these changes apply to? They apply to all trading services, whether it's commercial transactions, niche markets, rental property management in relation to trading services, so lease-ups, landlord-tenant agreements. Something that came up yesterday when we were speaking about this was the question of whether or not these rule changes apply to strata management. They do not apply to strata management. The language is very specific in the rule changes. It applies to trading services, whether that's buyers, sellers, assignors, assignees, lessors, or lessees. Let's talk about the new landscape of real estate in British Columbia. While you're reading the screen, I just want to talk about it. A few years ago, I think we all remember the slow food movement, where people really took time thinking about the food, considering the agreements, taking time to properly execute a recipe. Well, I'm going to suggest that we need to adopt the slow real estate movement, where licensees remember to take time for a thorough and consultative approach with their clients. No more hit and run real estate where you just shove paper in front of people and say, don't worry, it's standard. And I can understand that urgency, particularly in some markets, but it just doesn't serve the consumer. So we need to move from a sales-focused industry to client-focused profession. Licensees are increasingly going to have to apply professional judgment. And of course, you as managing brokers are going to have to develop robust policies and procedures for licensees to subscribe to when they're providing real estate services through and on behalf and in the name of the brokerage. Now, the goal of this, the shared goal, is a more professional and ethical real estate industry with better informed and protected consumers. Let's go on to consider what changes are ahead. Well, here's the big date. Rule changes effective June 15, 2018. New rules that have been proposed by the superintendent that came out for consultation in late March going through to April 20th is addressing conflicts of interest when acting for multiple clients. So that rule, and just make a note, it's 5-18, depending on where the superintendent lands with it, provides that if a licensee is currently representing two clients, for example, a seller and a buyer, they are potentially dealing with a prospective trade or a trade in real estate, the licensee, with the agreement of both of those parties, is able to release one client and continue acting for the other. If both parties don't agree, then the licensee will have to send out both parties. Now, of course, this would not be an issue that you would want to be the first time that the client heard of it right at the time the matter arises. So with this consultative approach that's going to be required, licensees should be having fulsome discussions with their clients before these conflicts arise. Discuss with them that in the course of a real estate providing real estate services, what sort of conflicts may arise and how you would suggest they be dealt with. In that way, when the matter actually arises, which would trigger the 518 rule, the client's already informed, can give considered consent or not, depending on what the circumstances are. The new rules that were under consultation also consider continuing professional education requirements for licensees and licensee language proficiency requirements. The final one is the remuneration must be expressed as a dollar amount when presenting offers to sellers. The section is 5-11.1, and I'm sorry, I'll stop section speak in a moment. But what that does, it sets out what the listing agent brokerage is getting, what a cooperating agent brokerage would be getting, any other referral or remuneration, so that every time that a seller is considering an offer or a counter offer, they'll know exactly what that amount is going to be. Now, I want you just to look at 518. This is the rule that sets out that the licensee may not provide trading services to any client in respect of that trade in real estate, or represent only one of the clients as a client in respect of that trade in real estate. So with the agreement of both clients, one client can be turned away or referred off, and the other client would remain represented. So it's very prescriptive what the written agreement has to be. So both parties on the opposing sides, whether it's two buyers that were going to be competing for the same property, a buyer, a seller, landlord, tenant, the written agreement has to have all of the elements that are set out in this rule. We've obviously been putting our minds to this, and when we find out where the superintendent has landed on this rule, we will be publishing information, principled facts, FAQs, that licensees can use to inform themselves. So let's talk about now preparing for change, how to prepare for change, because the minds of the managing brokers putting their mind to problem solving so that they can properly retrain and educate their licensees is going to be key to the success. Now, the importance of informed consent and proper disclosures is something that I'd like you all to put your mind to, is the overarching principles of undivided loyalty, confidentiality, conflicts, and informed consent. So those are the overarching principles that licensees are going to have to put their mind to. The council isn't able to develop FAQs for all scenarios. As you can imagine, every scenario is fact-driven, and it's going to depend on all of the circumstances. But licensees, in demonstrating their ability to apply professional judgment, have to keep those overarching principles in mind. So once again, a fully informed consumer is a protected consumer. A mere signature on a prescribed form may not be sufficient. As I alluded to earlier, just pushing a paper in front of a client and saying, don't worry about it, it's a standard form, and having them sign it. We've had decisions lately that demonstrate that a hearing panel does not find that practice sufficient. Licensees advise the clients decide. One of the issues that I often have consumers asking me about is they didn't understand. Everything was moving so quickly. And licensees really have to stop and understand the client is the one that decides, notwithstanding that the licensee is used to the machinations of a trade in real estate. It is the client that ultimately has to be protected and decide with fully informed consent. So once again, licensees should take a thorough consultative approach with clients and really not let their client abdicate their very important role as the principal. They decide. An area that we're putting our mind to is how to assist managing brokers in understanding the increased importance of brokerage oversight. So you need to actively ensure that policies and procedures are updated and regularly reviewed. Having a binder up on a shelf or having an electronic document that doesn't see the light of day from one week to the next is not sufficient. And your licensees, you need to require that they familiarize themselves with the brokerage policies and procedures. And I would expect many of you already have licensees sign off on that so that they fully understand their obligation to do so. As always, information barriers need to be robust to protect confidentiality, and particularly since in most instances, dual agency is prohibited. You need to ensure that all of your obligations as managing broker are met. And many of you have been longtime managing brokers and well know the burden and responsibilities that you have. And just for reflection, you can go to section 3.2 of the rules. And you might want to share that with your licensees so they fully understand what the degree of responsibility and oversight you have as their managing broker. I want to move on to the retention of records. And keep in mind with this, think about one of our auditors coming into your office and how you would deal with their requests. And I know our auditors are seen as being assistive and are often able to help brokerages improve their processes and procedures. But the questions that spring to mind for me is, how is the brokerage storing the disclosure forms? How are individual forms able to be retrieved? What is the brokerage's retention and destruction policy? And what sort of training is going to be provided to the licensees? One element that is going to affect your businesses, and particularly admin, is the volume of forms that are going to have to be collected, collated, and be available for inspection, which speaks to retention. It's going to be somewhat similar to when you first all had to set up your FinTrack requirements. So keep in mind the number of times that a licensee is going to have to provide a consumer with a disclosure of representation, a disclosure to unrepresented party, disclosure of remuneration when presenting offers. The less common will be the disclosure of dual agency, or the dual agency disclosure, and perhaps more commonly, we'll see where we get with 518, the agreement to release one client. So record management systems, as always, must be maintained in accordance with RISA, the regulation, rules, and bylaws. Just a hint, familiarize yourselves with section 8-9.1 and 8-10 of the rules and section 25 of RISA. 8-9.1 speaks to electronic records. So they've got to be easily transferable to print format for inspection of the council. Now, conflicts of interest. This is an area that we historically in this industry has been conflict tolerant. And historically, conflicts were resolved through sub-agency, implied buyer agency, dual agency, and conflicts can no longer be resolved for the most part through dual agency. So you want to put your mind to that the best way to address conflicts may require your licensees to refer clients to other licensees. This again is a discussion that licensees need to have with their clients at the onset of any relationship, so it doesn't come as a surprise. And as brokerages, you may want to put your minds to how within the brokerage you can develop efficient arm's length referral networks that provide protection of confidentiality, so the interests of the clients are best served. It's something that should be put into policy and not done on an ad hoc basis. We don't want an increase in unrepresented party. Continuing to act when there's a conflict creates potential risks for the client and the licensee. So this is an area that needs serious consideration. How to avoid conflicts of interest. We've been dealing with conflicts of interest for a long time. They've always been present, however, with the prohibition for the most part on dual agency, there's more instances that conflicts may arise. So discuss it with the client, review all disclosure forms that may be presented in advance, and the old rule of communicate clearly, early, and often. It's very key that licensees remember who they work for. Ask themselves a question anytime a conflict is arising: who do I work for? For whom am I a fiduciary? And then, using professional judgment, the licensees can deal appropriately with conflicts as they arise. Referral fees. This is a question that comes up. Referral fees must be disclosed, as always, as any remuneration under Section 511 to the client. You owe the client the duty of disclosure if you are going to receive any remuneration other than the remuneration that they are paying you. Further, under duties to clients, licensees have an obligation to disclose all material information to their client. So if you're paying out a referral fee to another licensee because of the real estate services you're providing to a client, you need to disclose that to the client. So disclosures under 511 must be made promptly and include the source, the amount, and any other relevant facts. I would also suggest that material information, a prudent licensee would want to put that in writing, although it's not strictly prescribed in the rules. And then, as with all disclosures, the licensee must deliver a copy of the disclosure to their brokerage. Now, one of the themes that we've been publishing lately in our e-blasts is an obligation for licensees to stay up to date. As a professional, licensees need to be knowledgeable about the expected standards of conduct for real estate licensees, and they are responsible for staying up to date about changes in law, regulation, and policies that affect their practice, such as changes to the Strata Property Act, the Residential Tenancy Act, HPO that's now called BC Housing, I believe, anything that relates to the provision of their real estate services to clients. They need to stay up to date. How to prepare your licensees. You've got a big job ahead of you because licensees, and I think we're all guilty of this, life is busy and there's all kinds of incoming information. It's very hard to prioritize where to apply your energies and your intellect. Licensees can rely on the council material. We already have a ton of material on the council's website, and I would encourage you to have your licensees get familiar with the council website and all of the information that is there. You're going to want to conduct training sessions. Council is working on a toolkit for managing brokers to assist them in this role. Also, very exciting, UBC, Sauder School of Business, has come up with an online course on the new rules. It's pretty much ready to go. We've just got placeholders for a couple of sections that will speak to the new rules that the superintendent will be talking about, we expect, in the next short while. So the ones that came out for consultation in March. So it's a really terrific online course. Licensees will be able to do it over a period of hours or a period of days. That will come out, we're hoping, around the same time as the forms in perhaps mid-May, but we're pretty much ready to go on that. And I think you will be enthused about the course and what it has to offer. So your licensees have to understand that they have to treat learning about the rules as a fundamental professional requirement. I refer to it as a chore. It's like washing dishes or making your bed. You can't avoid it. You simply must do it. And given the risks, a licensee that is not mindful of these changes may find themselves, perhaps unintentionally, facing discipline that could be of a life-changing nature. Going forward, we've already talked about all of these elements, but let's just refresh that. How will your business need to change? What policies will you need to develop? And how are you going to manage conflicts that arise? Again, how will you assess risk? And you've got to speak with your licensees about that. And what level of risk are you comfortable with?